All right. Let's see if I can manage to do this without too much nonsense. All right. Looks like I am live. Okay, let's see. Notify. All right, there we go. That way, almost anal AV Liz doesn't have to tell everybody for me. Hi, Chaos Warden. Hi, Michelle. All right, so you should be able to see everything. All right, so we left off rather abruptly. I might have to leave off again rather abruptly. I apologize. A couple of the neighborhood boys are coming over to do some more work again today, so I have to be able to monitor and supervise them because they're working with power tools and stuff like that. So my insurance is good, but I don't want to leave too much. So we left off yesterday right around here, I think right here. So we're going to continue on. I'm informed that there is more nonsense after this. So we'll see what's up.
Through the strip searching, you have to go through the turnaround, squat, and cough. You have to go through all those things to be able to fight for your rights properly.
You don't have to get arrested, by the way, to fight for your rights. As soon as the officers tell you can't do something, then you're good at that point. You have a cause of action. You don't need to get arrested for it. Unlike what this idiot says. All right, what do we got here? Yeah, neighborhood kids on the way. Boy, oh boy. Well, we'll keep going until we can't go anymore.
Retaliation because I challenged the police. And the court said, no, there's probable cause.
Because
you scuffled with the officer.
You can't fight the cops.
It's assault, whatever you want to call it. This is actually an easy case. Now we come to the heart of this case.
If he was at his house and he was wrongfully arrested, then he could scuffle with the police. But I don't recommend anybody does that.
Again, that is not good advice. Well, the good advice to not do it, yes. But to say that you have the right to scuffle with the police at your house, that is very, very situational at best. Let me do this so everybody can see the chat. And I'm supposed to do that. There we go. All right. So, again, very situational. Talk to a local attorney. You may or may not be able to resist arrest in your home or anywhere else. I don't know that there's ever an exception for your home, period. I don't know that there's an exception that says you can resist arrest at your home. I'm not aware of any state having that particular policy.
An exception. And the exception is, the example they give is jaywalking. So if there's a person protesting the police while jaywalking and the officer arrests the person for jaywalking, then it's, even though there's probable cause, because jaywalking is against the law, it is mostly, I think the word is typical, that the officer exercises discretion not to arrest that person for any person for that offense, and therefore the retaliation claim goes forward.
Okay, so two things. Number one, I just saw someone said that you requested a stenographer. You can hire your own private stenographer, which is exactly what we're doing in a case that's coming up. We're hiring our own stenographer to go into the case. So I want you guys to hear the process here, and I'm going to explain it. If you're an activist,
usually you do have to have your own court reporter. If you don't pay for one, or if opposing party doesn't pay for one, then you don't have one. So if you do intend on creating a record for appeal, you probably want to have your own court reporter there.
And you say, I'm filming police because I'm protesting the police. I'm protesting police by filming them. I want to catch them doing something wrong on camera. Doesn't matter. All you have to say is I'm protesting police. The 2001 case of Atwater versus...
Again, he's wrong on that.
City of Lago Vista says any infraction of the law done in front of a peace officer is arrestable. However, in 2019, Neil Gorsuch would write in his majority concurring opinion in Nivens versus Bartlett that came out of Alaska that...
It's still Neves. It's still Neves versus Bartlett.
If you are protesting the police and you happen to step in the street and you're jaywalking or you cross the street, you cannot arrest somebody. Just like there's...
the court doesn't hold that. The court says in the example, if there is an intersection where jaywalking is endemic, meaning jaywalking happens all the time, if the cops aren't arresting anybody else, but they arrest someone who is or has been vocal against the police, then at that point, you might have a retaliation claim at that point. But you have to look at the facts. It wasn't just that he was protesting a jaywalk. The court is not saying that you could protest while jaywalking without fear of being arrested for it. The court is saying that if no one else is getting arrested, and it's commonplace for jaywalking to happen, and it's commonplace for the cops to not enforce the law on jaywalking by making arrests at that intersection, but then you have been vocal against the police and you jaywalk and you are arrested for jaywalking, then there may be retaliation.
Constantly caveats for the police, constantly the caveats. I can list a dozen cases. I want to stay focused here. If you say you're protesting the police and then you jaywalk, it's an infraction, right? But if you're actively protesting,
it may or may not be an infraction. It may be a misdemeanor. I don't know. It would depend on state law. Every state can handle it differently.
The police, and you have your camera in your hand and you said to your camera, I am protesting the police. I'm protesting police. And then as you're protesting police, you happen to jaywalk, or you're jaywalking as you protest, and that cop arrests you. That is a slam dunk 1983 civil rights violation. You can.
It absolutely isn't. Like, you literally will have to prove that jaywalking happens there. It's endemic. It's endemic. It happens there all the time. You have to prove that. That's number one. Number two, you'll have to prove that police are aware of it. That police see it happening. You'll have to prove that the police don't enforce it. And you'll have to prove that you were protesting. Not that you said you were protesting. That's hearsay. But you have to prove that you were protesting. And then you may have a claim for retaliation. So he's oversimplified this example that the court gave to a bright line rule. It is not a bright line rule.
Quote Neil Gorsuch from his 2019 case of Nivens versus Bartlett.
Quote him from Nivens versus Bartlett. This fucking idiot. Gorsuch doesn't say that. Come on, let's do it. This is the example right here. This is the example. For example, at many intersections, jaywalking is endemic, but rarely results in arrest. So that's the first thing that you'd have to prove, that jaywalking is endemic at this intersection, but rarely results in arrest. How do you show that it rarely results in arrest? You have to show that the cops are aware of it and that they don't enforce it. If an individual has been vocally complaining about police is arrested for jaywalking at such an intersection where jaywalking is endemic, police are aware of it and don't enforce it, it would seem insufficiently protecting First Amendment rights to dismiss the retaliatory claim on the grounds there was undoubted probable cause for the arrest. So this all that you're doing here is you're surviving summary judgment in such a case because probable cause is little to prove or disprove the causal connection between the innocent injury, yada yada yada. So what would happen is, and we saw this in that Ninth Circuit case where the chalking case, what happens is that it snaps over to a question of fact. It's not a slam dunk at that point. You still have to convince the finder of fact that you were retaliated against. It is still, there's all that this would do is get you past summary judgment or a 12b6 motion, etc. That's it. That's all it does. I mean, Chili's so far out in left field on this that it's mind blowing how stupid and retarded he is.
This is the most important part and the reason why I'm showing you this video. Every time you pull out your camera and you're going to film a cop, no matter what the situation is, if there's going to be a piggy on camera, you start off by saying, I'm protesting police.
So again, in here, they never say that someone said that they've been protesting the police. The individual has been vocally complaining. So there are facts on the record, not some hearsay that you're trying to do to magic word you into a situation, but there are actually facts in the record that show you have been protesting. Not you saying you've been protesting, but show you've been protesting.
That's it. That's the whole line you say. Every single activist, every single auditor in the United States of America starts with that line. You start by saying that.
According to Chili, not according to the Supreme Court, not according to any courts of appeal, not according to any attorney, according to Chili, someone who had 5 felonies against him or something for GHB because he was a snitch. I mean, according to him.
I suggest to this court, this is the heart of my argument, that my case, Mr. Murphy's matter, is directly within that exception. And the reason is that my client, what he did wrong was he walked on the wrong side of the road, which I suggest in this case it was dark, it was late, it was rural. He didn't probably pay any attention to which side he was on. And I think the officer didn't really know the law either. I don't know if you've watched the video, but it's quite...
Is the video online? To be honest, I haven't even looked. See if anybody can find the Mason Murphy, Michael Schmidt. You can see the names here, and see if you can find that video on YouTube. See if it's out anywhere. And
he was saying it was racism. He was saying it was more racisms, and he hasn't even looked yet to see if it was more racisms. He said it was more racisms before he even looked.
Give me the link or send it to DLZ Clips, and let's see if we can find that video.
Startling.
Counsel, let me ask you this.
Sure.
The government asserts that the Neves exception is dicta. What's your response to that?
Well, I discussed that in my brief, Your Honor, and the Eighth Circuit has written that, and other circuits as well, that this court has to follow dicta of the Supreme Court. If it doesn't absolutely have to, I guess, but if it doesn't, there are going to be inconsistent results around the circuits. So that's really my response to that. I mean, let's imagine that the...
So what the court in Eighth Circuit is asking is, this is dicta, isn't this dicta? And the attorney's like, well, yeah, but it's Supreme Court dicta, so you should probably follow it, because if you don't follow it and other circuits do follow it, then there's going to be inconsistencies. Now, if there are inconsistencies, that would be great. Why would that be great? Because inconsistencies between circuits and how they handle something is a great reason for the Supreme Court to decide to take a case that would resolve those inconsistencies. So,
It's dicta or it's not dicta?
Oh, it's dicta. There's no question. It's dicta, sir. I agree with that. But let's imagine that the justices...
Okay, so let's take a pause real quick, because we're learning together here, and let's look up what dicta is. Let's just take a look. Let's read about when he said that's dicta.
Our 20-year constitutional law scholar doesn't know what dicta is. He's gonna have to look it up. Boy, howdy.
That's dicta. I'm trying to be more political because I will run for governor and I will win governorship and I will change this dog crap system from the top down. But just go ahead and make your own dirty joke about that's dicta. We are consenting adults here. So let's just take a look real quick. Let me see what you guys can see. And let me open this bad chicken big so everybody can see it. Oh, I'm so sorry.
What baffles me is how Chile can change federal law. As a governor. How is he going to change the system from the top down as governor? That doesn't make any sense. How are you going to change the system from the top down as governor? Last I checked, governors don't have anything to do with federal law or federal stare decisis.
There it is. So right here it says, what is dicta et SCOTUS? In the context of the Supreme Court of the United States, dicta, plural of dictum, refers to statements or remarks made by the court in a judicial opinion that are not essential to the decision of the case. Dicta are often additional comments, explanations, or expressions of legal principles that go beyond what is necessary to resolve the specific legal issue before the court. The key distinction in a Supreme Court opinion in between holding and dicta. So as you guys know, in the Supreme Court, they don't make rulings, they make holdings on what is constitutional or not constitutional. The holding upholds the Constitution or it gets struck down because it's not constitutional. A good example of that would be the 2000 case of Lopez versus United States versus Morrison that struck down the Violence Against Women's Clause.
The Supreme Court does not only deal with questions of constitutional law, they also deal with questions of federal law.
That was created by the Interstate Commerce Clause. So the key distinction in a Supreme Court opinion between holding and dicta. The holding is the legal rule or decision that is necessary to resolve the case and set a precedent for future cases. Dicta, on the other hand, are not binding precedent and are not required to be followed in future cases. However, dicta can still be influential and cited in subsequent legal arguments and decisions. Lawyers and legal scholars pay attention to the court's holdings because they establish binding legal precedent, which dicta are often considered persuasive authority but are not binding on the lower courts. It's important to distinguish between the two when analyzing Supreme Court opinions and their impact on the development of legal principles in the United States of America. So now you still have the dicta. You still have it. It's still there.
You still have it. Wow, you still have it. It's still there. What does that mean? What does that mean, Chili? What does it mean, Chili? What does it mean that it's still there?
So now let's go back to the original. No one can find that. So News Now Ninja took a look. So I'm still going to start all of my audits with I'm here protesting police because the dicta.
Well, you're retarded, and so who cares what you do?
Is there. Dicta is the simple quotes or things said at the Supreme Court level when the 9 monarchs who are appointed by the elitists who are run by the corporations are appointed to the court that's called Supreme. Then what happens is anything they say during the arguments or what they write in their holding is dicta. Well, no, they wouldn't write it in their holding or it wouldn't be dicta. What they say during oral arguments.
No, you idiot. No, you idiot. Dicta has nothing to do with what's in the oral arguments. Dicta is non-essential language that does not resolve the actual things necessary in the case to resolve. So if it's a contract case wouldn't get to the Supreme Court. Let's just assume it did. Because dicta isn't just a Supreme Court issue. Any court of appeal can have dicta. Any state Supreme Court or state court of appeals can have dicta in their opinions. It's always in the opinion. It's always in the holding. The it's an opinion. He says it's not an opinion; it's a holding. They're called slip opinions and majority opinions. So I think they're opinions. You could call them holdings. I don't really care. But it's the language in that opinion, in that holding, that's the important thing. On a contract matter, let's say that the court says, all right, because so and so had an obligation to do X, but they failed to do X, they breached the contract. Well, that's the holding, right? That's the stuff that's necessary to it. And then if the court goes on to say that contracts should have more clear language to state what X is, great. That's not necessary to the holding. That would be dicta. It's part of the opinion that's not necessary to resolve the actual issue that the court's dealing with. So the actual issue that the court dealt with in Neves versus Bartlett was whether or not Bartlett retaliated against Neves. That's the question that they needed to do, and they answered it. They answered it in Bartlett versus Neves by showing that Bartlett had, but by showing that there was probable cause. And so, in light of the foregoing, Bartlett's claim cannot survive summary judgment. The record contains insufficient evidence of the retaliation on the part of Trooper Waite. The only evidence of retaliatory animus is identified by the Ninth Circuit was Bartlett's affidavit stating that Sergeant Neves said, "Bet you wish you could have talked to me now." The allegation about Neves says nothing about what motivated Waite, who had no knowledge of the prior run-in. So the issue is that Waite made the arrest. Bartlett assisted in the arrest. And while Bartlett may have had a retaliatory animus, Waite didn't. So that was the holding of the court. That's what was necessary. That's what was necessary to resolve the issue. So he knew Bartlett had been drinking. He observed Bartlett speaking in a loud voice, standing close to Trooper Waite. He also saw Trooper Waite push Bartlett back. Tests whether the information the officer had at the time making the arrest gives rise to probable cause. We agree that it did. A reasonable officer in his position could have concluded that Bartlett stood close to Trooper Waite and spoke loudly in order to challenge him, provoking Trooper Waite to push him back, yada yada. That the example that was given had nothing to do with what was happening in Neves versus Bartlett. That's why it's dicta. There was no jaywalking. There was no intersection that has jaywalking being endemic. So it's just dicta. I don't know how to explain it better.
Arguments is dicta according to what we just read on ChatGPT. So I'm going to play a little more of this.
Well, there's a reason why attorneys don't use ChatGPT, and it's because attorneys who have used ChatGPT to do their research have I know they've been disciplined. I don't know if they've been disbarred, but there were attorneys who used ChatGPT to do research. ChatGPT ended up making up citations, and the attorneys didn't double check, and they ended up catching sanctions in front of that court, orders to show cause, etc. I think they were punished. I think they were disciplined. They may have been disbarred. I don't know. Don't really care. But the fact is, you have to do your own research.
This video, and then we're going to jump into some police videos I've been dying to show you guys.
Are back in conference thinking about the case. And to me, what they're worried about is the Mason Murphy scenario. That's their concern. I mean, I wish they'd said walking on the wrong side of the road instead of jaywalking, but they said jaywalking.
Let me ask for a little clarification. Are you saying that
Does he have two separate things he's drinking? He just drank out of one hand.
Some police videos I've been dying to show you guys.
Are back in conference thinking about the case.
Those thin, dry lips.
And to me, what they're worried about is the Mason Murphy scenario. That's their concern. I mean, I wish they'd said walking on the wrong side of the road instead of jaywalking, but they said jaywalking.
let me ask for a little clarification.
Like, what the fuck is that? What the fuck? Like, he's drinking two separate bottles of something?
Are you saying that the jaywalking exception is dicta, or that the exception to the no probable cause rule is dicta?
I think that it's both dicta, Your Honor. I would agree with that because the case itself, there was probable cause.
Chaos Warden says Lawful Masses did a video on a lawyer who got busted for using ChatGPT and the lawyer's disciplined. I remember, a lawyer was disciplined. I don't know if he was disbarred, but I know there was discipline.
And the court confirmed. I hope not disagree, Mr. Judge Malloy. I think it's this whole section of the opinion in Neves on the jaywalking says, okay, we're clarifying this. There has to be
A third now there's water too. This guy's like 3 open bottles. What the fuck is with that pinky being up?
probable cause. But there's going to be cases. There are going to be cases. Let me quote from Justice Gorsuch.
Here it is.
He did a concurrence in Neves. He said, nothing in our precedent, let alone logic, suggests that causation is always unprovable just because the officer had probable cause to arrest. So they were really thinking it through in this case, and they wanted to make sure that situations like jaywalking, like walking on the wrong side of the road, would still be coming forth to have justice for subjects whose constitutional rights were violated.
Okay, so
And again, the attorney is correct that that's what the court was thinking. But the Bartlett versus Neves court, they set out the kinds of things that you would have to prove, and they did not prove that in this particular Murphy versus Schmidt.
Oh, now what the argument in the court is right now, what the judge is saying to the lawyer is Mason Murphy, the plaintiff in this, who sued the cop for wrongfully arresting him for a First Amendment violation. He said it was a First Amendment, but then the cop took him back to the office, is what they call it. We call it the dungeon. He took Mason Murphy to the dungeon, and then they didn't have any probable cause to arrest him. So they looked up.
Wait, again, in Murphy versus Schmidt, both parties agreed that there was probable cause. We went over this yesterday. Both parties agreed there was probable cause in Murphy versus Schmidt. Both parties agreed. The parties agree. The parties agree. That means that Murphy and Schmidt both agreed that Schmidt had probable cause to arrest Murphy. They both agree there was probable cause. So anything that Chili's saying that there was no probable cause is Chili talking out of his ass.
The statute that was written in 1965 for blacks, and then it was updated again, I think, in 2000. I can't remember that last.
Sarah Cartland, aka Muttley, says that she is in Cyprus watching. Who is it? Alexander Christoforou? I watch him. He streams. He's in Cyprus all the time. Looks beautiful out there.
Last update with the Missouri Revised Code, MRC. So when you look that up, you're going to see that they continued this racist law in the year 2020 or 23, 2022 maybe. Someone can look up the statute. I think I have it right here. It's irrelevant. What I'm trying to explain to you is the lawyer is arguing that there has to be an exception made. You can't just arrest people. It's unreasonable. It's unreasonable to arrest Mason Murphy. It's a violation of the Fourth Amendment because even if he arrested him with probable cause under Missouri Statute 300.405, it's still under the Fourth Amendment would be considered unreasonable. And that.
Well, I didn't hear any of that argument. I don't see. There's no talk about the Fourth Amendment. There's no talk about unreasonable. So no, and I didn't hear in the oral arguments any discussion of the Fourth Amendment or unreasonableness. So this again is just Chili talking out of his ass. The arrest was reasonable. It was based on probable cause. The parties agreed that there was probable cause, which means it was reasonable. There's nothing else to it. If there's probable cause, then the arrest is reasonable.
That's what the lawyer is arguing, and that the dicta would state that if you're protesting police, you can't be arrested for jaywalking. So he's trying to align the dicta that Judge Neil Gorsuch said in the Nivens case, that, you know what, Gorsuch says in the Nivens case that we have to allow an exception for people who are protesting the police.
One cult says arrest with probable cause is unreasonable now. I guess, dude, like, it doesn't make any fucking sense to me. Like, the parties agree there's probable cause. Probable cause is like the basis for arrest. You know, Fourth Amendment says that arrests have to be based on probable cause, and so there's probable cause, so there's no Fourth Amendment violation.
And if they're jaywalking, they shouldn't be arrested because it would be clearly retaliatory. So they pull
it's not clearly retaliatory if you're arrested for jaywalking. That's not what the court said. There's a test that has to be applied. You have to take the specific fact pattern and apply it to the test, and that's what the court did in this particular Murphy versus Schmidt. They applied the test. Murphy's assertion that a reasonable opportunity for further investigation or discovery will show that no one else in recent memory has been detained or arrested by any of the law enforcement officers. So here's Murphy asserting it. Murphy is trying to say that that if we are allowed to do discovery, then I'll be able to show that there is a history of people walking on the opposite side of the street, the officers seeing it and not being arrested by it. it does little to show that officers typically witness. Oh, so they didn't actually. They just said that that no one else in recent memory has been detained or arrested. But then what the court says is that does nothing to show that officers typically witness violations and exercise their discretion not to arrest, because that's also part of the test. Murphy also asserts that walking on the wrong side of the road occurs all the time on the highways with wide shoulders in the situation where where the officers have probable cause to make arrests, but typically exercise their discretion not to. So again, these are threadbare recitals. This is Twickball. You have to actually plead facts. So
pull over Mason Murphy on the side of the road. He's just walking on the road. They asked him for identification. And he says, I'm not going to give you ID. They have a spirited conversation, which is probably, F you. And then they arrest him because he tells them to F off. They don't have any probable cause to arrest him. They get
they arrest him because the officer thinks he has probable cause. Now, if you remember, probable cause just means that they have to believe that Murphy was probably committing a crime. That's it. That a crime was probably being committed and that Murphy is probably the one who's committing it. That's it. Then the officer takes it back and they figure out which crime he was committing. The officer was too stupid to figure out the wrong side of the road. He knew something was wrong. But he knew something was wrong. You assume that he's making the arrest. Again, Murphy versus Schmidt did not make it to the fact-finding stage. This was 12b-6, right? I think this was a 12b-6. Motion, 12b-6, motion dismissed based on qualified immunity. So this never got to the fact-finding stage, so we don't know what Schmidt said or didn't say. They probably hadn't conducted discovery because they were talking below on if discovery continued, a reasonable opportunity for further investigation or discovery will show that no one blah blah blah. So they probably have not done discovery yet. This is on at the beginning of it. This is just on the pleading. They didn't have a pleading that was sufficient to survive summary judgment because they didn't allege sufficient facts to show that, number one, walking on the wrong side of the road was common. It was endemic. Number two, officers are aware of this and they exercise their discretion not to make arrests based on walking on the wrong side of the road. Number three, that Murphy was protesting the police. And then number four, that he was arrested when other similarly situated people were not. He didn't show that. He didn't show it. It was a failure of pleading.
back to the police station and they decide they look up this old racist law and they charge him with the old racist law. But they didn't have probable cause to begin with. It's on video. We can't find the video, but we know it's...
The parties agreed that there was probable cause.
It's on video. So, of course, Mason Murphy sues him for a First Amendment.
Emma, Chili does not... I don't know what rock you've been under, Emma. I remember you from a long-ass time ago. A long-ass time ago. Like 4 or 5 years ago. I remember you in my comments. But no, Chili does not have a license to practice law. He's a 20-year constitutional law scholar who doesn't know his asshole from his elbow.
Violation because he's saying you're arresting me for free speech. The police say, we didn't arrest you for free speech. We arrested you for Missouri Revised Code 300.405. Now, the lawyer for Mason Murphy at the federal court, they're in federal court here. So he's talking...
This oral argument is not just in federal court. This is at the 8th Circuit Court of Appeals.
To these monarchs, they're all also appointed for life. This has got to change. We cannot appoint people in our government for life. This has got to change. None of you should be appointed to life for your job. Nobody should be appointed to a government position for life. It's ridiculous. And then they get qualified immunity. And they get qualified immunity from the 19...
They get judicial immunity. They don't get qualified immunity. They get judicial immunity. Any decision that they make in any of their opinions or cases or whatever, they cannot be sued over. If it's an administerial thing, then they may be, but any they can't be sued for their opinions. They have free reign to make whatever opinions they want. Your remedy is not to sue them. Your remedy is to appeal or seek certiorari to the Supreme Court.
1951 case of Tenney versus Brandoff. My blood pressure. I mean, we are living in absolute frickin' tyranny. I can feel my heart pounding as I explain this to you. And just...
absolute tyranny that you're not allowed to walk the wrong way down the street. I mean, like, I get it. That seems a little nanny-ish. I understand that. You should be responsible for your own welfare. That's my opinion. If you want to walk with your back to oncoming traffic, I don't really care personally. You're taking your own life in your hands. But is that really like tyranny? I mean, I don't know. It doesn't. There are a lot of things I think you can complain about before you get to the point of complaining about a law against walking the wrong way down the street. I think.
So you know, the lawyer loses, and the judges at the federal level, they're one step away. They're going to apply for certiorari to go to the Supreme Court to have the Supreme Court hear the case. The federal judges rule against Mason Murphy, and they said they could arrest him without probable cause.
No, the court did not say that they could arrest Murphy without probable cause, because the parties agreed that there was probable cause. The question of probable cause was not before the Eighth Circuit Court of Appeals, because the parties fucking agreed there was probable cause. How can you be this wrong? He's listened to the oral arguments. Has he just not read? Has he just not read the opinion? He seems to know that Murphy loses.
The Fourth Amendment is completely and utterly wiped away.
This has nothing to do with the Fourth Amendment. Nothing to do with the Fourth Amendment. This is a First Amendment issue. Retaliation or speech is a First Amendment issue. It's a First Amendment issue. That's why there's no mention in this case about the Fourth Amendment. There is zero mention. But you see lots of First Amendment. You see lots of First Amendment. It's a First Amendment retaliation claim. It's a First Amendment case. It's not a Fourth Amendment issue. Not even a little bit.
Counsel, would you address the issue of whether or not this was a lawful order, more specifically?
Sure.
And because I think it relates to the district court's opinion, basically found that there was a violation of Missouri statutes here.
Yeah.
For the
I
state.
think that goes to the Heibel case. And I will confess to you, I'm living on exceptions here. I've got two exceptions. I got the Neves
Heibel is in your trifold.
exception and now the Heibel exception. So let me just read you from Heibel.
So I don't know why we're going to Hibble. They say Heibel. I say Hibble. Maybe I'm wrong. Maybe I'm dumb. I've never met Hibble or Heibel. I doubt they have either. They're in the 8th Circuit. Hibble is 9th Circuit, so I doubt they've met him. But Hibble was really Fourth Amendment. That's the big part. And then there was a slight detour into the Fifth Amendment on it. The issue in Hibble was there is a Nevada statute that requires you to identify yourself to the police if they have reasonable suspicion. You have to identify if they have reasonable suspicion. So the facts of the case is the police were called that there was a domestic disturbance to, I think it was Hibble's residence, or what they thought was Hibble's residence. They're on their way there. They see Hibble. He matches the description and everything. So they pull him over and they demand his ID. And he refused to identify himself. And so they ended up arresting him for failure to ID. It made its way all the way up to the Supreme Court. And he was asserting a Fourth Amendment right against unreasonable search and seizure. And he also made a Fifth Amendment right claim about identifying himself would be akin to testifying against himself. And I think this was just to pull my it didn't say yet, right? It didn't say yet. I don't think it said. All right. So I believe this is one of the rare Clarence Thomas decisions. It's Kennedy decision. Damn it. Anyway, so Kennedy hand waves away the Fifth Amendment thing by basically saying that the court can't think of any situation where just your name itself is incriminating. Something being incriminating is saying, like, I robbed a bank. That's incriminating. It's saying that you committed a crime. Saying my name is Bob isn't incriminating. And you're going to say, like, well, what if there's an arrest warrant out for Bob. Well, your name isn't the incriminating thing. Your name is just kind of like an identifier of you. The incriminating thing would be if you said, yes, I did the crime. That's incriminating. Yes, I was there. Like they're investigating you over bank robbery. If you said, yeah, I was at that bank on that date, that's incriminating evidence. You have a Fifth Amendment right not to provide witness against yourself. But if the police have a tip that says Bob was at the bank on that date, and Bob is probably the person who committed the crime, and they get an arrest warrant for Bob, you saying, yeah, my name is Bob, is not incriminating. I hope that makes sense.
Petitioner's concerns are met by the requirement, and Heibel 2004 or something, that's approximately right, are met by the requirement that a Terry stop, and this is a Terry stop, under an objective standard, he was on the wrong side of the road, reasonable suspicion.
Well, this is the argument that this is a Terry stop. I don't know, because the parties agreed that he had probable cause.
Terry stop must be justified and reasonably related in scope to the circumstances which justify the initial stop. That's long-standing, clear law. Under these principles, an officer may not arrest a suspect for failure to identify himself if the request for identification is not reasonably related to the circumstances justifying the stop.
Okay, let me break down Hibble for you real quick. In your trifold, Hibble versus 6th Judicial District Court, right here in Nevada, because Nevada was what you call a stop and ID state. So in Hibble, what happens is they arrest Hibble because he's not going to give identification. It goes to court, and then I believe it's the Supreme Court. I think it's the Supreme Court of the United States. I'm pretty sure. It wasn't a circuit court. It was the Supreme Court of the United States. And what they decide in Hibble is that if the cop stops you and you're in a stop and ID state, and he states that he has reasonable articulable suspicion of a crime, and he can articulate a single articulable fact of why he believes that you're involved in a crime, and he says, because I have reasonable articulable suspicion and I have a single articulable fact of criminality, you have to ID yourself. Not so fast.
No, he doesn't have to. He doesn't have to explain any of that to you. He says, no, you have to ID. And then if it goes to court, if you fail to identify and you get arrested for failing to identify, and then you try to challenge it in court, then at court he has to state to the judge. He has to explain his reasonable suspicion to the judge. He has to state the articulable facts that a reasonable person would be able to, or a reasonable officer would be able to apply that officer's skill and experience with to arrive at the conclusion that crime may be afoot.
You have to ID yourself in the reference of how you identify.
You have to ID yourself in the reference. Wait, maybe I missed something.
Aldi, you have to ID yourself. Not so fast. You have to ID yourself in the reference of how you identify. Articulate a single articulable fact of why he believes that you're involved in a crime. And he says, because I have reasonable articulable suspicion and I have a single articulable fact of criminality, you have to ID yourself. Not so fast. You have to ID yourself in the reference of how you identify. Articulate a single articulable fact of why he believes that you're involved in a crime. And he says, because I have reasonable articulable suspicion and I have a single articulable fact of criminality, you have to ID yourself. Not so fast. You have to ID yourself in the reference of how you identify.
Am I retarded? That doesn't make any sense. You have to ID yourself.
Of criminality, you have to ID yourself. Not so fast. You have to ID yourself in the reference of how you identify. Articulable fact of criminality, you have to ID yourself. Not so fast. You have to ID yourself in the reference of how you identify.
I have no idea what he's talking about.
I identify as a good citizen. You've identified yourself.
They have the language, I believe, in here. All right, here's the language for the Nevada Revised Statute. Any peace officer may detain any person whom the officer encounters under circumstances which reasonably indicate that the person has committed, is committing, or is about to commit a crime. That's reasonable suspicion. So there is a statutory basis for the reasonable suspicion stop. Then number 3, the officer may detain the person pursuant to this section only to ascertain his identity, and the suspicious circumstances surrounding his presence abroad. Any person so detained shall identify himself and may not be compelled to answer any other inquiry of the peace officer. So if you identify as good citizen, you're fucking going to jail. You're fucking going to jail. What they mean by identify is to actually give like your name, address, and phone number, or something along those lines. Let's do a little research. And we're looking for, what was it? 123. They have definitions. Definitions. All right. Oops. That's it. That's the only statute on it. That's the only one. All right. This is an ineffective assistance of counsel issue. I'm going to just posit that the purpose of the statute is not so that you can identify as good citizen. The purpose of the statute is to allow the officer to determine who you are. So I don't think I would love to see any authority that Chile can cite where you can just identify as whatever the fuck you want to identify as and still comply with the statute, because the officer may detain the person pursuing the section only to ascertain the person's identity. So now the cop he can detain you as long as he wants to, or as long as he needs you to identify you, for him to identify you. And it's not about what you identify as, it's for the cop to ascertain your identity. And then you shall identify yourself. You shall identify yourself. I don't believe that means that you can just say I'm good citizen. I might do some research on that later. I don't know.
You don't have to pull your ID out of your wallet and give it to the copper because he says I have a reasonable articulable suspicion.
I don't believe that you have to pull out ID, but you have to give enough identification to allow for the police to identify you. So it might just be your name and your address and your date of birth and your social security number or whatever, something along those lines. But you have to be able to give the officers enough to identify you. If you don't, they're going to arrest you for failing to ID. Now, the easiest way to do it, and as an attorney, I wouldn't have any issue with it. In fact, I would prefer it if you just pulled out your driver's license and handed it over, because then you're not talking. And remember that anything you say can and will be used against you. One of the things that cops like to do is they like to try to get you to talk, because if the more you talk, the more likely you are to make a mistake. So I would prefer it as an attorney if my client, if they're required to identify, if they would just pull out their driver's license and hand it over. It just makes my job easier. The less, as an attorney, the less your client talks to the police, the easier my job is.
And I have a singular articulable fact of criminality. You still don't have to give them your identification. You do have.
Ray Knight says, so jaywalking isn't a crime in Nevada. I don't know about that. I haven't looked it up. So why is it still valid for the police to stop and detain him under 171.123? I are you talking about Hibble? Hibble wasn't detained for jaywalking. It was a domestic dispute, if I remember correctly. Maybe I'm wrong. They received an assault. The report see a man assault a woman. Uh, so a man assaulting a woman. I was assuming domestic. So when they arrived at the scene, they found the truck parked on the side of the road. A man was standing by the truck, and a young woman was sitting beside it. The officers observed skid marks in the gravel behind the vehicle, leading him to believe it had come to a sudden stop. The officer approached the man and indicated he was to investigate a report of a fight. The man appeared to be intoxicated. The officer asked him if he had any identification on him, which we understand is a request to produce a driver's license or some other form of written identification. That's the court saying this. The man refused and asked why the officer needed to see identification. The officer responded he was conducting an investigation, needed to see some identification. The unidentified man became agitated and insisted he did nothing wrong, yada yada. The provision provides the person who is loitering under circumstances which justify suspicion he may be engaged in or about to engage in a crime, commits a violation if he refuses the request of the peace officer that he identify himself and gives a reasonably credible account of the lawfulness of his conduct and purpose. Here, there's no question the initial stop was based on reasonable suspicion, satisfying the Fourth Amendment requirements of Brown. Petitioner did not allege the statute is unconstitutionally vague. The Nevada statute is narrow and precise. The statute in Collender had been interpreted to require the suspect to give the officer, quote, credible and reliable, end quote, identification. In contrast, the Nevada Supreme Court has interpreted NRS 171.123 to require only that a person suspect disclose his name. Oof! Oof! Oof. Well, there we go. The suspect is not required to provide private details about his background, but merely state his name to an officer when reasonable suspicion exists. Well, oof, there goes your good citizen argument, Chili. There goes your good citizen argument. It's not what you identify as at the time, it's your fucking name. It's your name. Chili's always looking for like these shortcuts and workarounds.
Have to say how you identify. And on the Fifth Amendment card coming out, should be done tomorrow. Good Lord, we've been working on this thing. The Fifth Amendment card coming out tomorrow, it gives you a step-by-step tutorial of when the cop asks you for your ID, you give him the Fifth Amendment card, you have a copy of the Fifth Amendment card, and you just go right down that list, and it has Hibble on it. And it explains to the cop, I've invoked my Fifth Amendment right, you can't question me anymore. And now we're down to number 4, and he says, well, I have reasonable articulable suspicion.
Invoking your Fifth Amendment right does not stop the cop from questioning you. It does not. Absolutely does not. There is only one way to stop a cop from questioning you, and that is after arrest. If you invoke your right to counsel, if you invoke your right to have an attorney, then they can't question you anymore unless a significant amount of time has passed, unless they provided you with an attorney, unless you come back and say that you want to talk. There's some exceptions to it, but right then and there, as soon as you demand an attorney, they have to stop questioning you because they can no longer ask you questions without your attorney present. You have a Sixth Amendment right to counsel. So no, the Fifth Amendment does not stop the cops from questioning. Now the Fifth Amendment right was also addressed in here. Petitioner further contends that his conviction violates the Fifth Amendment's prohibition on compelled self-incrimination. The Fifth Amendment states that no person shall be compelled in any criminal case to be a witness against himself. To qualify for the Fifth Amendment privilege, a communication must be testimonial, incriminating, and compelled. Respondents are just told that the statements that the statute requires are non-testimonial and so outside the clause's scope. We decline to resolve the case on that basis. To be testimonial, an accused's communication must itself explicitly or implicitly relate to a factual assertion or disclose information. Stating one's name may qualify as an assertion of fact relating to identity. Production of identity documents might meet the definition as well. As we noted in Hubble, acts of production may yield testimony establishing the existence, authenticity, and custody of items the police seek. Even if these required actions are testimonial, however, Petitioner's challenge must fail. Must fail. The Fifth Amendment assertion must fail because in this case, disclosure of his name presented no reasonable danger of incrimination. Because the cops weren't looking, I don't even know if the cops were looking for someone, I don't even know if the cops were looking for someone with Hibble's name. That would be incriminating. The Fifth Amendment only prohibits only compelled testimony that's incriminating. Noting that where the answer of the witness will not directly show his infamy, but will only tend to disgrace him, he is bound to answer. A claim of Fifth Amendment privilege must establish reasonable ground to apprehend danger to the witness from his being compelled to answer. The danger to be apprehended must be real and appreciable with reference to the ordinary operation of law in the ordinary course of things, not a danger of imaginary and unsubstantial character, having a reference to some extraordinary and barely possible contingency so improbable that no reasonable man would suffer it to influence his conduct. As we stated in Castigar, the Fifth Amendment privilege against compulsory self-incrimination protects against any disclosures a witness reasonably believes could be used in criminal prosecution or could lead to any other evidence that might so be used. Suspects who have been granted immunity from prosecution may therefore be compelled to answer, and with the threat of prosecution removed, yada, yada, yada. In this case, petitioner's refusal to disclose his name was not based on any articulate, real, and appreciable fear that his name would be used to incriminate him or that would furnish a link in the chain of evidence needed to prosecute him. As best we can tell, petitioner refused to identify himself only because he thought his name was none of the officer's business. Even today, petitioner does not explain how disclosure of his name would have been used against him in a criminal case. While we recognize petitioner's strong belief that he should not have to disclose his identity, the Fifth Amendment does not override Nevada's judgment. The contrary, the narrow scope of the disclosure requirement is also important. One's identity is, by definition, unique, yet it is, in another sense, a universal characteristic. Answering a request to disclose a name is likely to be so insignificant in the scheme of things as to be incriminating only in unusual circumstances. See Baltimore City, yada yada, suggesting that facts the state could readily establish may render any testimony regarding the existence or authenticity of them insufficiently incriminating. In every criminal case, it is known and must be known who has been arrested and who is being tried. Even witnesses who plan to invoke the Fifth Amendment privilege must answer when their names are called to take the stand. Still, a case may arise where there is a substantial allegation that furnishing identify at the time of a stop would give the police a link in the chain of evidence needed to convict the individual of a separate offense. In that case, the court can then consider whether the privilege applies, and if the Fifth Amendment has been violated, what remedies must follow. We need not resolve those questions here. So, there may be a time when furnishing your name would give the police evidence of some other crime. Maybe. Mosquitoes. Look at mosquitoes. But that is something that the court couldn't even kind of comprehend. It couldn't even come up with an example of when that would be. And you might notice that the Nevada Revised Statute is still good law. So apparently, no one else has come up with a situation where supplying your name would invoke Fifth Amendment privileges. All right, so Hibble doesn't really give you a good place on Fifth Amendment, on a Fifth Amendment argument to not identify yourself. It's not a good jumping off point because number one, the court concluded that Hibble was required to give his name, and number two, the court said, well, there may be some place, sometime, somewhere where identifying yourself would implicate Fifth Amendment protections. We're not going to give an example of it.
And a single articulable fact of criminality. Okay, cool. Look at number 4. You don't have probable cause. And because you don't have probable cause, you can't get my ID. I gave you the ID I'm going to give you, which is the Fifth Amendment card.
Again, Hibble stands for the proposition that if you have reasonable suspicion, not probable cause, reasonable suspicion under the statute, under the Nevada statute, reasonable suspicion is sufficient. Here, there's no question that the initial stop was based on reasonable suspicion, satisfying the Fourth Amendment requirements noted in Brown. So, reasonable suspicion. I I might not go through chat at the end. So let's see. Let's see what Grey Knight is asking. If Chili's case does not involve a stop and detention for jaywalking, then why are we talking about jaywalking at all? We're talking about jaywalking because Chili brought up a case. It's this case on the screen right here, Murphy versus Schmidt, where they raise the issue in Neves versus Bartlett about jaywalking. I hope that answers your question. We're talking about jaywalking because that's the soup du jour.
You can't even ask me for my ID again without my attorney. You're questioning me.
Well, see, you hear what he just said there? You can't ask me about my ID again without my attorney. Any real constitutional law scholar would be like, wait, attorney, that's Sixth Amendment. So why are you talking about Fifth Amendment when you're bringing up attorneys? Because that's Sixth Amendment. The right to counsel is the Sixth Amendment. Sixth Amendment right to counsel.
If you know your rights, you can stand on your rights. You just have to know them inside and out. There's a reason why I don't get arrested very
If you know your rights, you can stand on your rights. You just have to know them inside and out. You don't appear to know your rights, Chili. You don't appear to know them.
often because I know my rights inside and out. I know them like I know them like I know them. So
I know them like I know them like I know them.
let's keep listening because there's some more gold in here that I can continue to educate a little bit.
Now, let me detail that a little bit. In the stop be justified and reasonably related in scope to the circumstances which justify the initial stop. That's long-standing, clear law. Under these principles, an officer may not arrest a suspect for failure to identify himself if the request for identification is not reasonably related to the circumstances justifying the stop.
And they stopped him for no reason. He was walking down the road.
Detail that a little bit. In the Heibel case, we're down in Nevada. There's a phone call for an assault with a description of a car. The officer sees a guy standing next to a car that meets the description of the car. Is not reasonably related to the circumstances justifying the stop.
The officer's actions must be justified at its inception. Asking questions is an essential part of police investigations. In the ordinary course, a police officer is free to ask a person for identification without implicating the Fourth Amendment. Interrogation relating to one's identity or a request for identification by the police does not, by itself, constitute a Fourth Amendment seizure. Beginning with Terry v. Ohio, the court has recognized a law enforcement officer's reasonable suspicion that a person may be involved in criminal activity permits the officer to stop a person for a brief time and take additional steps to investigate further. To ensure that the resulting seizure is constitutionally reasonable, Terry stop must be limited. The officer's action must be justified at its inception, so the officer has to have reasonable suspicion at the inception, and reasonably related in scope to the circumstances which justify the inference in the first place. So if the officer stops you because he thinks that you're about to commit armed robbery, and then he does a Terry frisk on you, when he pats you down and he finds that you're not carrying a firearm, then he can't change his mind unless he finds drugs. Let's say he doesn't find drugs or anything like that. He can't change his mind and start questioning you about drugs unless he found something in the course of his investigation, which would then give him reasonable suspicion about the drugs. So it's not just a free-for-all license, but asking for the identity is going to be reasonably related. Our questions make clear that questions concerning a suspect's identity are a routine and accepted part of many Terry stops. The ability to briefly stop a suspect, ask questions, or check identification in the absence of probable cause promotes strong government interest in solving crimes and bringing offenders to justice. If there are articulable facts supporting a reasonable suspicion that the person has committed a criminal offense, that person may be stopped in order to identify him, or to question him briefly, or to detain briefly while attempting to obtain additional information. A brief stop of a suspicious individual in order to determine his identity or maintain the status quo momentarily while obtaining more information may be most reasonable in light of facts known to the officer at the time. So, I don't know what to tell you here.
And they stopped him for no reason. He was walking down the road.
Detail that a little bit.
Does it say that they stopped him for no reason? Does it say he stopped him for no reason? He saw him walking down the road. He stopped his car, approached Murphy, and asked Murphy to identify himself. Okay. It doesn't say he stopped him for no reason. He saw Murphy walking down the right side of the road with traffic. So he might have just steel manning this particular argument. Schmidt might have just not known which statute it was. He might have known, generally speaking, you can't walk down the right-hand side of the road. You have to walk down the left-hand side of the road. And he just didn't know which statute to charge him with. So, I mean, I don't know. I nowhere in here does it say that Murphy was stopped without for no reason, without reasonable suspicion.
In the Heibel case, we're down in Nevada. There's a phone call for an assault with a description of a car. The officer sees a guy standing next to a car that meets the description of the car. He goes over and says, "Hey, who are you?" "I'm not telling you." So it goes on from there. The argument. The
So so he walks over to a guy by a car and says, "Hey, who are you?" And he says, "I'm not going to give you my ID." "Who are you?"
arrest. And the
Right. So I believe that in Hibble, the vehicle matched the description. A red and silver GMC truck. All right. They got to the scene. They found the truck. So I'm assuming that the truck matched the red and silver GMC truck description. I'm going to guess that because they found the truck, the red, silver, and red GMC.
critical fact is that in that case, the officer didn't know who had committed the assault. They were looking for the perp. So identification of the person standing next to the matching car, I mean, he wasn't the guy, but that's not important.
No. It is important.
Well, so the Hibble court doesn't go on to say that the identification in the Hibble case is the most important thing. The cops want to know who they're talking to. The cops didn't have a bolo for Hibble. They received an afternoon telephone call reporting assault. The caller reported seeing a man, not Hibble, a man. The caller reported seeing a man assault a woman in a red and silver GMC truck on Grass Valley Road. That's it. So how is the name important in Hibble? Well, the name is important because the officer has the right under the statute to ask for the name. And having a name is usually pretty helpful in figuring out who you're dealing with, what you're dealing with, and why. Show me one case where that particular statute was invoked with a demand for ID, where the court said that went too far, that the officer didn't have the right to demand the ID. Just one time. Just one, Chili.
It is important that he wasn't the guy, but yet he was still arrested for not identifying. It is important. That's a very important fact.
The critical thing is that
Well, so after the investigation is completed and after you've determined who is or isn't a suspect or who is or isn't guilty, yeah, I mean, that's great. But the problem is that when the officer went into this, they had a description of a truck with a man assaulting a woman inside of it. That's what they had. They had a description of a truck. And they show up, and Homebro meets the description. There's a man and a woman. There's a truck that matches the description. Heading your way now. Okay. So there's a man and a woman. The truck matches the description. How are the officers supposed to know at that point, before they conduct their investigation, whether or not they're guilty? It doesn't make any sense. That doesn't make any sense. I'm not a huge fan of Terry stops, but it doesn't make any sense that the officers have to know who committed the crime before they conduct their investigation of it.
officer needed to ID the perp. In this case, Mr. Murphy was ID'd, not his identity, but the person who had committed it was clear because he was standing right in front of him when it happened. So that's the difference. Now, there's other issues about what is called other evasive behavior. I mean, so there's a big question issue with refusing to identify yourself. You didn't identify yourself, but you didn't have any duty to identify yourself. I think under the Heibel exception, there is no duty to.
Well, what happens? Like riddle me this, Batman. I don't know if this is the case because I don't really care. But what if Schmidt had two options? Number one, he could issue a citation. Three options. Number one, he could issue a warning to Murphy for walking down the wrong way, walking down the street the wrong way. Two, he could issue a citation, like a ticket. Or three, he can make an arrest. Now, If he can't identify Murphy, he's probably not going to be able to issue a citation. And issuing a warning wouldn't really go very far. If you're arguing with the cops on the side of the road, something that attorneys don't recommend you do, if you're arguing with a cop on the side of the road, the cop's probably not going to get a feeling like a warning isn't going to go too far. So you really take away a lot of the officer's choices to de-escalate. Gray Knight says, all jaywalking laws are a result of lobbying by car manufacturers. They serve no practical purposes. That's really stupid, Gray Knight. That's really stupid, and you're a fucking retard. What do car manufacturers gain by jaywalking laws? Hear me out here. If a car collides with a pedestrian, the car is going to be damaged. And the more damaged the car is, the more likely someone's going to have to buy a new car. The more likely it is they have to buy a new car, the more money that the car manufacturers are going to make. So wouldn't it be in the car manufacturer's best interest to have few to no traffic laws so that people would have to buy more cars? So you're a fucking retard, sir and or madam. You're a fucking retard. And you should feel bad. You should feel bad for making everybody else stupider by participating here in chat. Murbies, read a goddamn history book, you potato. I'm correct, factually, historically, deal. Well, if you assert it, then that must be the case. I mean, you've already said one retarded thing. Why not just assert that you're correct and, and that'll make it all better. You fucking idiot. All right. Well, I guess I'm not going to deal with Mr. Gray Knight anymore. Looking out my back door. I don't know if that's going to work. Anyway, we'll see if it does or doesn't. It doesn't really matter. All right, on with the show.
To identify himself because it's in the case. The exception is when there's no statute in Missouri requiring you to do it, which was present in Nevada.
Well, does it lawful?
Because Nevada was a stop and ID state. That's why there was already.
Right. So there's no statute requiring him to ID in Missouri, but there is a statute requiring him to walk on the left-hand side of the road. So the officer has some sort of limited means by which he can enforce it.
Stop and ID state. That's.
Looking out my back door, and we're going to go night. Yeah.
The precedent set, which is why any encroachment on our rights at all whatsoever, we have to fight tooth and nail. So just listen.
Now there's other issues about what is called other evasive behavior. So
I do agree that we should fight encroachments on our rights tooth and nail.
there's a beg the question issue with refusing to identify yourself.
Okay.
You didn't identify yourself, but you didn't have any duty to identify yourself. I think under the Hybel exception, there is no duty to identify himself because it's in the case.
Okay, so evasive behavior. The cop walks up to you and says, hey, you buy a car, give me your ID. Okay. Bro, do that to me. Do that to me. And when I have the Fifth Amendment card, do it to someone who has the Fifth Amendment card. And if you catch it on camera with the Fifth Amendment card, he arrests you, I'll bail you out of jail. If you use the Fifth Amendment card and you got it on camera and he arrests you, I'll get you out of jail. So he's talking about evasive behavior. If a cop walks up to you and demands my identification, and he's going to get, well, from me, you know what he's going to get. But from anybody in here, put a 1 in the chat if you would have some evasive behavior.
I've seen clips of Chili giving his ID to officers. I've seen it. When the screen went black? Is the screen black? To officers. I've seen it. I don't see. It looks like I'm still going. So, but I've seen Chili ID. So I don't know. I don't know what he's talking about there. He ended up IDing in Ironton when he was arrested. He ended up IDing in Nevada when he was arrested. So.
If you were standing out in a parking lot in a public space, standing by a car, and the cop ran up to you and said, hey, give me your ID, put a 1 in the chat if you would exhibit some sort of evasive behavior. What are we talking about here? You're going to receive some evasive behavior? I would say evasive.
So remember that reasonable suspicion is a very low bar. For example, Wardlow versus Illinois, or Illinois v. Wardlow. I don't remember which is first, but Wardlow. In Wardlow, the cops roll into a high crime area, and they see Wardlow standing at the corner of a building, holding an opaque, meaning like a black bag in his hand, like you buy when you buy like alcohol from a liquor store. You get the black bag so you can't see through it, an opaque bag. So they don't know what's in the bag, right? The facts of the case is Wardlow sees them, they see Wardlow, and Wardlow takes off running. Now, does that give them reasonable suspicion? Believe it or not, it fucking did. The circumstances with him being in a high crime area, him standing at a corner of a building holding an opaque bag and takes off running, that gave them reasonable suspicion, not only to stop him, to detain him, but to search him. They got to search the bag because people in these high crime areas tend to be selling drugs, and they tend to carry weapons to protect themselves while they're selling drugs. And so, I mean, it's a very low bar, and it's acting suspicious. Acting suspicious is generally the basis of most reasonable suspicion stops. There's something going on. Oh, wow. All right. And we're going to do that. Perfect. Vox. Well, Vox. I'm gonna trust what Vox says, because who the fuck is Vox and why do I care? Anyway, so acting evasive can be enough. There's like one of the reasons why you want to assert your Fifth Amendment is because there's another case where the officers, I don't remember the name of it, the officers started questioning a suspect. There had been some murders, and they start questioning a suspect, and he is agreeing to talk to them, which you shouldn't do. But then they start asking him about a shotgun that he owns, and he stops answering. He doesn't assert his Fifth Amendment right, but he stops answering, and that's evasive behavior. And they were able to use that against him, the fact that he was willing to answer questions, until they started asking about the shotgun that he owned, and then all of a sudden he was no longer willing to answer questions. That's evasive behavior. And that was enough to give them probable cause, not just reasonable suspicion, but probable cause to arrest him for the murders. So,
behavior. Put it in the chat if you would show some evasive behavior if a cop decided he was going to walk up to you and demand your identification based on a racist law in Missouri.
The exception is,
Again,
we haven't the argument that it is racist is somewhat tangential and unsupported by the facts. Well, that's interesting.
He was going to walk up to you and demand your identification based on...
How come I can see it here? I can't see it here. That's interesting. Oh, because I'm on. There we go. There we go. And there we go. Bye-bye. I don't know why people think that I owe them arguments. What's that fuckwit's name? That CJ Grisham guy. People like to come into my channel and try to start arguments with me in my comment section. And I don't know why you think I owe you an argument. I don't care. I just don't care. Like, you want to argue with me about something stupid like a Vox article? Like, I don't fucking care, bro. Go take your shit somewhere else.
That was Murphy and Hibble. Sorry.
when there's no statute in Missouri requiring you to do it, which was present in Nevada.
Well, doesn't lawful order arguably, in other words, if the officer orders you to identify yourself, doesn't that arguably fall within the statute? Assuming, let's say we had a question.
Listen to that frickin' judge. He's a frickin' federal judge. He's been frickin' appointed for life. For life. This douche.
How dare he ask a question? Because he's been appointed for life. How dare he ask a question?
Douchebag talking. You are such a douchebag, bro. You don't know the answer to this? I'm an autodidactic constitutional law scholar, and I know the answer to this.
I'm an autodidact. I don't even know what the fuck that means. Autodidactic. Autodidactic. Self-taught. Wow. Fancy words. So so what the judge is asking about is the interpretation of a statute. So let's listen to the judge's question again.
You are such a douchebag, bro. You don't know the answer to this? Freaking appointed for life.
Arguably fall within the statute. Doesn't lawful order arguably, in other words, if the officer orders you to identify yourself, doesn't that arguably fall within the statute? Assuming, let's say we had a question.
So they're talking about a Missouri statute that requires you to obey lawful orders. So that's what the judge is saying. This is a question of statutory interpretation, and the statute in question is a state statute. It's a state statute. So the federal court judge is not going to be the ultimate arbiter of how that is interpreted. It's going to be up to the state court generally to determine how that particular statute is interpreted and what is required in that statute. So I'm going to have to go here. The neighbor kids just got here. So anyway, so on a question of statutory interpretation, whether or not a statute includes a requirement to identify, that's a valid question to ask. It's a valid question to ask. Anyway, that's it for today. Thanks for watching, and have a great day. Identify. That's a valid question to ask. It's a valid question to ask. Anyway, that's it for today. Thanks for watching, and have a great day. It's not stopping. Identify. That's a valid question to ask. It's a valid question to ask. Anyway, that's it for today. Thanks for watching, and have a great day. It's not stopping. That's a valid question to ask. It's a valid question to ask. Anyway, that's it for today. Thanks for watching, and have a great day. Huh. Well, that's fucking amazing.